Hello, and welcome to Fast Eviction Service, Southern California's leading eviction and collections law firm. Today's update is critically important for every landlord, property manager, and legal professional handling evictions in California. We'll cover eviction notices in 2025, what's changed, why it matters, and what you must do now to stay compliant. If you serve an eviction notice the same way you did in 2024, you could be at risk. Major changes in response timelines and notice procedures went into effect January 1st, 2025, and being unaware is not an excuse. Let's start by addressing why this update matters. The eviction process begins and ends with notice. According to the California Court's Self-Help Guide, landlords must give a written notice to their tenant before filing an unlawful detainer lawsuit. In 2025, procedural changes mean that if your notice, your form, or your service method is wrong, you may face delays, increased costs, or even an entire case dismissal. That's especially true in Southern California, where local ordinances layer on top of state law. Picture this. A property manager uses an old 3-day pay or quit form, serves it incorrectly. Tenant responds late because the timeline changed. Next thing you know, your case is delayed months. If you're handling multiple properties, these procedural mistakes can cascade. So let's get into the specifics. First and foremost, timeframes have changed. Effective January 1st, 2025, under Assembly Bill 2347, tenants now have 10 court days, excluding Saturdays, Sundays, and judicial holidays, to respond after being served with an unlawful detainer complaint. Previously, they had only 5. Additionally, if service is by mail, additional days may apply. So what does that mean for your notices? You must update your standard templates. Ensure you're referencing the correct service deadlines. When you serve a notice, e.g., a 3-day or 30-day, you need to anticipate that the defective service or incorrect timing could give tenant grounds to challenge. Double-check that the form you use is compliant with current statutes and local court rules. For example, the Self-Help Guide lists the types: 3-day, 30-day, 60-day, or 90-day notices. Practical tip: mark your calendar for response deadlines when you file your unlawful detainer. Don't assume the old 5-day rule still applies. Now, let's review notice types and the impact of local law. Under state law, the most common notices are 3-day pay or quit for unpaid rent, 3-day cure or quit for lease violations, 30 or 60-day no-fault termination, depending on tenancy length. However, in jurisdictions like the City of Los Angeles, the Just Cause for Eviction Ordinance, JCO, imposes additional requirements. For example, landlords in the City of LA cannot evict a tenant for non-payment of rent unless the amount owed exceeds the fair market rent for the unit. Also, JCO requires that all eviction notices in the City of Los Angeles must be filed with the LA Housing Department within 3 business days of service. What this means for you: always verify whether your unit falls under a local ordinance such as JCO or an RSO, Rent Stabilization Ordinance. Don't rely solely on state law templates. Local rule overrides the state minimum in many cases. Make sure your notice references correct local conditions, for example, the correct grounds, compliance date, and any required filing with local housing authority. In 2025, tenant protections continue to evolve, and they affect the eviction notice process significantly. For example, under new law, a survivor of domestic violence can request a lock change, and the landlord must change locks within 24 hours of receiving a written request and verification. Additionally, AB 2347 gives tenant more time to respond once served. But it's not just procedural. Some protections impose substantive limits. For example, the landlord must ensure you are not evicting in retaliation, must maintain habitability conditions, and cannot use self-help evictions, like shutting off utilities or changing locks without court order. So for notice servicers, your checklist must now include: confirm tenant is not entitled to special protections, domestic violence, wildfire impacted, subsidy recipient. Confirm the method of service meets both state and local standards. Confirm the tenant's response window calculation, and anticipate that some protections might extend or toll deadlines. Based on what we know so far, here are common mistakes I urge you to avoid. using outdated notice forms that reflect pre-2025 timelines. Serving by a method that doesn't comply with state and local rules, e.g., posting versus personal service versus mail, and fails to trigger correct response clock. Failing to verify whether the unit is subject to a local ordinance, e.g., JCO, which requires extra filing or limits grounds. Miscalculating the timeline for tenant response. Remember, under AB 2347 tenants now get 10 court days to respond. Ignoring tenant protections such as lock change requests, wildfire relief, etc., which might delay or complicate the court process. If you check off a simple notice service checklist every time, you'll dramatically reduce avoidable delays. Consider including date and time of service, method of service, version of form used, local ordinance applicable, response deadline calculation. To wrap up, here are the strategic takeaways for landlords and property managers in Southern California. Update your notice templates now to reflect 2025 procedural requirements. Train your team, property managers, leasing staff, legal assistant, on the new timelines and service methods. Audit your portfolios. Identify in which jurisdictions your units sit, e.g., LA City, Orange County, Riverside, and verify local ordinance applicability. Consult counsel if you're unsure about whether a notice is valid. A malformed notice can push your case back by weeks or months, money you don't want to lose. Document everything, from service records to responses to tenant communications. Good documentation protects you if the tenant files a motion challenging service or form validity. In summary, 2025 is not just a continuation of past years. Between longer tenant response periods under AB 2347, updated statutory guides from the California Department of Real Estate and Courts, and expanding local protections, the eviction notice process has changed in meaningful ways. If you rely on 2024 methods, you risk noncompliance. If you're a landlord or property manager in Southern California, and you'd like assistance reviewing your notice templates, training your team, or auditing your eviction processes, contact us at 1-800-686-8686. We're here to help you protect your business and manage risk. If you found this video valuable, please hit the like button, subscribe for more landlord-tenant law updates, and leave a comment below with any specific eviction notice topic you'd like us to cover next. Thank you for watching. I'm with Fast Eviction Service, Southern California's leading property management expert in eviction and collections law.